Negotiable Instruments Act, Section 20, Inchoate Stamped Instruments. Section 20 of the Negotiable Instruments Act, 1881 deals with inchoate stamped instruments and addresses situations where a person signs and delivers a stamped paper that is blank or incomplete, thereby authorizing another person to complete it as a negotiable instrument. This provision is important because it balances commercial convenience with legal protection by recognizing such authority while safeguarding parties against misuse. 1. Meaning of inchoate instrument. The term inchoate means incomplete or unfinished, and an inchoate stamped instrument refers to a paper that is duly stamped, signed by a person, and delivered to another, but left either wholly blank or containing an incomplete negotiable instrument. Such an instrument is therefore lacking essential particulars, such as the amount or the name of the payee, at the time of signing. This provision recognizes that despite such incompleteness, the instrument may later be completed in accordance with the authority given. 2. Essential conditions under Section 20. For Section 20 to apply, the following elements must be present. A. Proper stamp. The paper must be stamped as required by the law relating to negotiable instruments in force in India. B. Signature. The person must sign the instrument. C. Delivery. The signed stamped paper must be delivered to another person. D. Blank or incomplete. The instrument must be either completely blank or incomplete in material particulars, and once these conditions are fulfilled, Section 20 becomes operative. 3. Prima facie authority to complete the instrument. By signing and delivering such an instrument, the person grants prima facie authority to the holder to complete or fill in the instrument as a negotiable instrument for any amount specified, provided it does not exceed the value covered by the stamp. This confers legal authority upon the holder to complete the document within the limits permitted by the stamp. 4. Limit on amount. The authority to complete the instrument is subject to the limitation that the amount filled in must not exceed the value covered by the stamp. For example, if the stamp duty permits an amount up to 1 lakh rupees, the completed instrument cannot lawfully exceed that sum. 5. Liability of the person signing. The person who signs an incomplete instrument becomes liable on it in the capacity in which he signed, such as maker or drawer, to a holder in due course for the amount filled in within the limits of the stamp. Accordingly, the signer cannot avoid liability merely because the instrument was incomplete at the time of signing. 6. Protection of holder in due course. Section 20 affords strong protection to a holder in due course by providing that if the instrument is duly completed and comes into the hands of such a holder, the signer remains liable for the amount filled in within the limits of the stamp. Accordingly, even if the amount inserted exceeds what was originally intended, the signer is bound so long as it is within stamp limits, thereby promoting confidence in commercial transactions. 7. Limitation of recovery by other holders. The section contains an important proviso that if the instrument is not in the hands of a holder in due course, the person who signed it cannot be made liable for more than the amount he originally intended to be paid. Accordingly, a holder who is not a holder in due course cannot recover beyond the amount actually intended by the signer, thereby maintaining fairness and preventing misuse. For more details, contact us.